Greetings everyone, my name is Olukayode and today we will be examining an issue that has generated much controversy and has garnered diverging perspectives in relation to it. We'll be examining Domitilla that began as a groundbreaking Nollywood film in 1996 and subsequently it has become the center of a heated trademark dispute. So in order to give the examinations a structure, and since the case falls within the sphere of trademarks, I think it is quite important to firstly give a kind of clarification or definition to the concept of trademark. Then following that, we're examining the background of this case, the ruling of the tribunal, things to take note of. We will conclude and that will be all. So in order to ensure that we are on the same path as I am, and to follow through appropriately, I have prepared PowerPoint slides that will enable us to get the gist of what I am saying and to follow through with what I am saying. So having laid down this premise, we'll move on to the first end of this discussion, the concept of trademark. Now, pursuant to section 67 sub 1 of the Trademarks Act, the section gives us an insight as to what the concept of trademark entails. But basically, a trademark can be seen along the lines of any sign, any word, any phrase, any symbol, a logo, design, or a combination of all this that is used by a person or by a company to distinguish their goods or services from that of others. So aside this statutory framework that is in place for the definition of trademark, it has also received judicial blessings in numerous cases, and notably will place reliance on Ferredo Limited versus Ibeto Industries Limited 2004, where a trademark is described as a distinctive sign that allows consumers to identify goods for purchases. So the essence of trademark in itself is such that it establishes a connection between the service or goods and the owner. So when a trademark is registered, it has the effect of enabling the proprietor, the actual owner, to institute actions in the event that another person is trying to act in contravention with the right that is duly attributed to him as being the owner. So basically, I think this is what the concept of trademark entails, and so that is what the concept of trademarks primarily entails. And in light of this, it is important to move on to the next aspect of this discussion. This branch will border on the facts of the case. In 1996, a particular filmmaker, Zeb Ejiro, released a movie, Domitilla, and the movie centered around the life of a particular young woman who was trying to make a living as a prostitute in Lagos. The movie recorded huge success. Even in 1999, a sequel to the movie was released, Domitilla 2, huge success as well. So the lead actress played the role so well that she already became widely recognized as Domitilla. So, about 2 decades after this period, Zeb Ejiro, the filmmaker, announced his intention to produce a reboot of the movie, and he invited the same actress to come and play a role in the movie, but there was no correspondence between them regarding the payment, so he had to continue the preparations and it was done without her. But not long after that, the actress, through her lawyers, issued a cease and desist letter. Then she was claiming that she had rights over the name because she had registered Domitilla and Device as a trademark in September 2020 under Class 41, such that covers entertainment services. Then the filmmaker filed a petition through his lawyers. He challenged all this. Then he insisted that he already used or was already using the name since 1996 very long before our own registration, and he accused her of bad faith since she was aware that the origination of the name came from him in 1996, not something else. Then he was asking for the trademark to be cancelled. Then in response to that petition, the actress, through her own lawyers too, she was of the view that she already applied for the mark 10 months before he talked about the reboot. So it was very wrong of the filmmaker to accuse her of acting in bad faith. So she also contended that there was a jurisdictional issue, that the filmmaker has missed 2-month window to institute such action because the trademark was published in October 2021 and this petition came in February 2023. So, pursuant to that, she contended that the tribunal no longer had the power to entertain the matter. Then, she also raised another point that when it comes to trademark, what matters in law is the first register it, not the first person to use it. And since in view of this particular principle in relation to the case, she was the first to register it, she also maintained that she was right in law. And she also had a claim that her fans, even till this day, call her by that name. So she has already generated this kind of perception of the public as Domitilla. Therefore, she is the rightful owner of the trademark. But when it was taken to the tribunal, the position of the tribunal with respect to the case was such that aligned with the petitioner in this case, because the tribunal was of the view that the true proprietorship of a trademark is a person with prior claim to the mark. Then the tribunal relied on particular case, the Albasan trademark case, and the tribunal, in view of this, stressed that proprietorship is based on first use, not just registration. So, in the application of this principle, the tribunal found that the Domitilla movie is actually the creative work of the petitioner, that is Zeb Ejiro, and that the respondent's link to the name only came as a result of the fact that the petitioner cast her in the movie. So for that reason, our attempts to register Domitilla in her own name amounted to bad faith. So on the basis of a claim of goodwill and all, tribunal also was of the view that she was dishonest in filing the application because the actual origin of the mark, she knew it, and it originated from the petitioner, not her own creative work. Then, on the basis of the jurisdiction that she raised to, the tribunal discountenanced the argument. Instead, tribunal relied on section 22 sub 1 and section 18 sub 7 of the Trademark Act. So these provisions give the registry the power to withhold or correct errors in already accepted applications, and that as a result of these sections, it gives the proper basis for hearing the matter. But generally, the position of the tribunal was such that the respondent is not, or was not, the owner of Domitilla. Our application was therefore refused, our acceptance letter was cancelled, and all the documents that were issued in her name were declared to have been issued in error. So, in view of the entire scenario, the fact of the case, the holding of the tribunal, my perspective to it is that this Domitilla case really emphasizes the need for Nollywood generally to take intellectual property rights or intellectual property more seriously. So the actress acted a lead role in the movie, and as a result, she became attached to the movie. But the fact that she acted in it does not mean that she is entitled to possess ownership in light of the particular mark. So, in my view, I think that the tribunal was right to have cancelled the registration, because otherwise it should have opened doors for actors to just start claiming rights over film titles that they have acted in, and this will have the effect of creating a very huge controversy, confusion in our laws on intellectual property. So I also think that the entire case is also a lesson, because actually the Trademark Act requires that trademarks are to be registered. Although it is also acknowledged that the fact that a trademark is not registered does not mean that a person does not have any right at all. But that is even a more complicated thing. So it is better for trademarks to be registered. If it happens to be copyright do not necessarily need to be registered before they can be rights accruing to the owner. But copyright will not cover the title in this case. It can cover the storyline and other things, but it will not cover Domitilla in itself. So for me, the key takeaway in this trademark issue is about protecting what has been built, and in this case Zeb Ejiro has already built something, and it is amounting in bad faith for another individual to claim what has been built by another person. So what intellectual property seeks to protect particularly is the creative invention of a person, and in this sense the Domitilla only came into existence because a person thought it was a creative invention of a person. So it will be unfair to override all that, and I think that the position of the tribunal in respect of this case is very sound. Conclusively, the concept of this trademark dispute is such that opens our eyes to the dynamics of what can go on within the creative industry, and the essence of this discussion is to enable us to understand the position of the law in circumstances like this. And to effect this, we have considered the concept of trademarks in itself. We have examined the background to the case in question, the ruling of the tribunal, my very own perspectives, lessons to be learned, and much more things. And the particular essence of this is to ensure that we further enrich our knowledge of intellectual property. So thank you all for being a part of this, and I hope that it has been educative and entertaining the same way it was for me. Thank you.